Hey everyone, and welcome to today's Explainer. Look, if you're tuning into this, chances are you or maybe someone you really care about might be facing a situation that honestly feels completely overwhelming. When someone you love gets arrested, the sheer uncertainty of it all is incredibly stressful, right? Especially if you're a total beginner and have never had to deal with the justice system before. But take a deep breath, because you are definitely in the right place. Today, we're putting together a highly reliable, step-by-step guide specifically designed for families who are completely new to the Placer County justice system. By the time we wrap up here, you're going to have a clear, structured roadmap of exactly how the bail process works. We're going to completely remove the guesswork and hopefully help you feel a lot more empowered during a really tough time.
Okay, let's dive right into this. Here is our roadmap for today. First, understanding Placer County bail. Second, scheduled bail versus judge review. Third, the 4 steps at arraignment. Fourth, crucial timelines and data. And finally, number 5, what happens after bail.
All right, starting off with Section 1, Understanding Placer County Bail.
So, picture this. At the very center of an arrest, whether that's in Auburn, Roseville, Tahoe City, or really any other community in this area, is the Placer County Superior Court. This is the trial court where all county criminal proceedings and felony cases are ultimately resolved. Whether a case ends through a plea negotiation, a dismissal, or a full-blown trial, every single serious case stops right here. Understanding this court's supreme role is absolutely crucial. It's your very first step to removing the confusion and taking back some control. You see, it isn't just a physical building. It is the ultimate decision maker for serious charges. And knowing exactly how it operates, well, that is going to give you a massive advantage.
Moving right along to Section 2, Schedule Bail versus Judge Review.
And this brilliantly illustrates the 2 completely distinct paths a case can take, which honestly clears up the most common question families have when they're first starting out. For misdemeanors and low-level felonies, bail is actually set automatically from a standard bail schedule right after booking. It's built for fast processing. The court doesn't even need to get involved at this early stage, which means a bail bondsman can start working their magic almost immediately. But for serious felonies, the path is entirely different. Bail is not automatic. It actually requires the defendant to appear before a judge at an arraignment hearing, where that judge personally determines the bail amount. This distinction is so vital for you to know, because the standard schedule moves in hours, but waiting for a judge's review, that typically takes days.
Which brings us to Section 3, the 4 steps at arraignment. Since those serious charges require a judge, let's actually step inside the courtroom for a second. If you've never been to an arraignment, here's the exact 4-step sequence of what goes down. First up, the charges are formally presented by the district attorney's office in open court. Second, the defendant enters a plea. Now, usually, they're just pleading not guilty at this early stage to preserve their legal rights while their attorney reviews the case. Third, bail is argued and set. The prosecutor might push for a higher bail based on the charges, while the defense argues for a lower amount based on ties to the community, and then the judge personally sets that final number. And fourth, future court dates are scheduled, things like preliminary hearings and pretrial conferences. And that's it. That is the entire sequence, demystified.
Okay, let's hit Section 4, Crucial Timelines and Data.
Now, what's really interesting here is the number 48. Under California law, the court has exactly 48 hours to arraign a defendant who is in custody. But here is the massive trap that catches beginners off guard. That 48-hour window strictly excludes weekends and holidays. This is a huge piece of data to keep in mind. I mean, think about it. If an arrest happens on a Friday evening, you might not actually see a judge for arraignment until the following Tuesday. Knowing this exact timeline is exactly what prevents families from absolutely panicking when the weekend passes without any forward movement.
10%. Write that down, because this is your financial baseline. Under California law, 10% of the total bail amount is the standard premium for a bail bond. What this does is create absolute cost certainty for families. It literally does not matter if the bail was automatically assigned from that standard schedule we talked about, or if it was heavily argued over and set directly by a judge. If the bail is set at, say, $50,000, your premium is going to be 10%, period. No surprises. You know exactly what financial reality you're dealing with.
So how do professionals actually navigate these strict rules and timelines? Well, experienced local bail bondsmen utilize deep, specialized local knowledge. They closely monitor the specific arraignment schedules. Based on decades of experience, they can anticipate likely bail ranges before the judge even opens their mouth. They're totally prepared to move the very instant bail is set. And honestly, most importantly, they understand the court's overall rhythm. They use this insider knowledge to set highly realistic expectations for you when you are navigating this crazy system for the very first time.
Finally, Section 5. What happens after bail?
I've got some major reassurance for you here. The paperwork, the payment, and the posting process with the jail is handled completely over the phone. A lot of families assume they have to rush frantically down to the courthouse, empty their pockets for metal detectors, and stand in endless lines just to hand over paperwork. You don't. Your family never actually needs to appear at the court in person to complete the bail bonds process. The bondsman facilitates the whole shebang directly with the jail system on your behalf. This lets you focus entirely on just being there and supporting your loved one.
So, the crucial point is, what comes next? We know from our 4 arraignment steps that future court dates get scheduled, and this leads us to the absolute most important question for the ongoing case. What happens if you miss a future court date, like a preliminary hearing?
Well, the reality is pretty severe, and beginners absolutely need to know this up front. Missing any scheduled appearance results in a bench warrant being issued for the defendant's arrest and the bail bond being completely forfeited. Every single court date is mandatory. The court schedule has to be respected without exception, which is exactly why having a reliable bondsman remains a critical point of contact. They help make sure those dates are met.
Now, we do need to factually address the worst-case scenario that sometimes keeps families up at night: bail denial. It is relatively rare. It's typically reserved for capital offenses, cases where there's a documented extreme danger to public safety, or if the defendant has a clear history of failing to appear in court. If a judge does deny bail outright, the defendant remains in custody, and a qualified defense attorney has to formally step in to seek a bail reconsideration hearing.
To wrap up today's explainer, I want you to remember this one thing. Navigating the justice system successfully requires not just money, but a thorough understanding of the local court's unique rhythm and rules. The Placer County Superior Court has its own very specific way of operating. Throwing money at it alone doesn't solve this. Understanding those exact steps and data points does. Which leaves us with one final thought to ponder. Now that you actually know the precise roadmap and the strict timelines of the Placer County system, who are you going to trust to guide you through it?